Broadcast is now starting. All attendees are in listen-only mode.
Hi, everyone. This is Nichole Attallah and Sarah Nash, and welcome to Employment Law for Government Contractors. Yes, it's different. Thank you for joining us today. My name is Nichole Attallah. I'm a partner in the labor and employment practice here at PilieroMazza, and I am with Sarah Nash.
Hi, everyone. I'm an associate here. I work with Nichole in the labor and employment practice.
We are a full-service law firm. We have offices in Washington, D.C. and Boulder, Colorado. In addition to our labor and employment practice, we have a very well-known government contracts practice, business and corporate practice, and litigation practice. So we're very excited to be with you today to talk about FAR Part 22. And what most people might be thinking, or maybe not because you actually signed up, is why do we want to know about FAR Part 22? And this is the first time I've done a webinar like this one that's specifically supposed to be an overview of a section of the FAR, because what I've found in 8 years of practicing in this area is that while we might know that bits and pieces of these regulations apply, it's very rare that we have actually gone through and uncovered all of the stuff that's in FAR Part 22 and some of Part 23, admittedly, we'll be talking about today. And so we wanted to take this opportunity to talk to you about everything that's in this part of the FAR and what types of things that you should be thinking about if you're not already thinking about them. Some of this stuff, in full disclosure, for example, we'll touch on the Service Contract Act and Davis-Bacon Act. We do full-day seminars on these topics. So this particular webinar is not intended to be a full training or primer on any of these topics. It is supposed to highlight what is covered in FAR Part 22, really talk about the high-level nuts and bolts of what you should be thinking about when you're looking at these provisions. And then if you have any questions about anything that we're talking about, or if you have specific questions that relate to any of these sections, please feel free to give us questions as we go along. We will answer as many questions as we possibly can throughout the hour today. We encourage you. We like questions, so please don't be shy. And if we don't get to your questions, feel free to send us follow-up questions. We'll get to them as soon as we possibly can. So again, FAR Part 22 is really about the application of labor laws to government acquisitions. It deals with the general policies regarding labor relations, equal employment opportunity, prevailing wage, those kinds of things. And it's really an opportunity for you to see all of the types of labor and employment components that you need to comply with. I will say that even though you should at some point in time, on a Saturday night when you're real bored, peruse through FAR Part 22, we will talk about the elements of your contract that you should be paying attention to. So remember, your contracts are still your key. They're your guide to knowing what's actually going to be incorporated into your contract. So I always think it's a good idea not to just assume that all of this will apply to you, because chances are it won't, but components of it very well might. So it's really important that you understand the full scope of what you should be complying with.
So as Nichole mentioned, there's a lot that goes into FAR Part 22. This is just a summary of some of the more meaningful parts that might be in your contract. We're going to go over most of these with broad strokes. You'll see that there's some equal employment opportunity, non-discrimination issues. There's your standard Davis-Bacon Construction Act issues, and service contracts are also covered. You also have child labor requirements, trafficking. So there's a lot that goes into this, but ultimately it's going to depend on what's in your contract. Not all of this is applicable to each contractor. It really depends on what's specifically in your solicitation or your contract.
So let's get into some of the first provisions, and we're trying to kind of go in order so that you'll see how it's laid out in FAR Part 22 as well. And the first general proposition in FAR Part 22 is this idea of how does the government interact with unions? Like when you, a contractor, have a unionized workforce on site, there's this, elephant in the room, which is that this is at a government location. And so your government client is obviously going to be impacted by the relationship that you have with the unionized workforce. The government's ultimate goal is to make sure that no disputes or happenings, so to speak, will interrupt the business of the government, right? So while recognizing that principle that the government has an interest in making sure that its work gets done, this particular section, the labor relations section, really says that the government's supposed to stay out of the middle of any interaction, negotiation, dispute that the contractor might be having with that unionized workforce. That includes organizing campaigns as well. So if there's activity on the site or off the site where a union is trying to organize a workforce, the government is supposed to be staying out of the middle of it. Now, I've seen more than one situation where that did not appear to be the case, and it can really create complications for you as the contractor who's trying to make sure that you're abiding by the National Labor Relations Act while the customer is kind of putting some pressure on you. But what the government can do, they have a couple of tools at their disposal. They can refer a concern to the National Labor Relations Board, so they can ask the NLRB to intervene in some particular way. The other thing that most agencies have is an agency labor advisor. And sometimes the government will encourage mediation or will encourage the agency labor advisor to keep up with what's going on in that negotiation so it can ensure that its business will go uninterrupted. For example, if they know that there are ongoing negotiations or they know that there's been a strike vote, they may ask you to provide a strike plan. Like, what are you going to do if this workforce does in fact strike? So they do have some capability and responsibility to understand the status of what's going on, but they are not supposed to inject themselves or take sides in that particular action. The other component of this particular slide is overtime. And we all know that the government is particularly sensitive about overtime. And sometimes the question is, well, why are you sensitive to overtime when you, government, is asking me to get all of this work done in such a short period of time? But obviously we know, just like if we were working in a commercial setting, overtime costs any employer extra money, right? You have to pay time and a half for hours worked over 40. And in some states, you have to pay more than that on the 7th consecutive day. So it's important to understand that the government feels that if there are increased costs to you, the contractor, that will ultimately get passed on in some way, shape, or form to the government. So this particular section of the FAR basically says that contractors are not supposed to use overtime unless there are very specific reasons to do this. Now, I will say here that the type of contract that you have matters, right? So if you have a firm fixed price contract, this may not impact you the same way that, say, a time and materials or other type cost reimbursable contract might impact you. Because a firm fixed price contract, here's your price, that's all the government's going to pay, regardless of whether that person, whether you incur overtime or not. If it's a situation where the agency is impacted, contracting officers are only supposed to grant overtime or grant approval for overtime in very certain situations. And those are, to meet essential delivery or performance schedules. If they've got to have, their fighter jet or whatever they've got to have, their tank on their program to operate systems on a specific schedule, they could request the overtime. To make up for delays that were beyond the control of the contractor, so things happen, they could approve it in those particular cases. Or to make sure that they don't have any bottleneck. So basically, times when they need to do something in order to get the work of the government done that's of particular importance and can't be delayed further. Otherwise, they are not supposed to be approving overtime. FAR Part 22.2 basically says that you can use convicts to perform work. However, it says that if you are in a situation where you want to use convict labor, the government has a responsibility to make sure that those particular people are not exploited in the provision of that labor. And that's all this really says. It says, you know, you can use convict labor, but don't exploit people.
Straightforward, right? Hopefully, one would hope. So as we sort of preluded to, there's a discussion in these FAR provisions that deals with construction and manual labor. And when you think construction and manual labor, mostly you're going to think of Davis-Bacon related acts and generally prevailing wage requirements that come along with those statutes. And so generally this covers manual labor and laborers who are performing on construction contracts. And what that means is not just new construction, but any alteration or repairs, including painting and decorating of public buildings or public works. And there's a lot of positions out there. So you can think of general maintenance workers, you can think of painters, you can think of electricians, plumbers. All of that gambit goes into this bucket of people who are covered by these FAR provisions. And if you're ever in doubt, the contracting officer is supposed to be including these provisions in your contract. So when you see FAR Part 22.3 or .4, you generally know that these requirements apply to your contract. And I think we mentioned this earlier, that FAR Part 22 essentially incorporates a lot of statutes and regulations that already exist out there. And specifically in the construction world, there are wage rate requirements, formerly known as Davis-Bacon Act. Now a bunch of different statutes comprise it. There's overtime requirements that Nichole talked about. Any employees who work over 40 hours per week have to be paid time and a half. There's the Copeland Anti-Kickback Act, which essentially says that you cannot induce or require an employee to pay back any of the contractual wages that you've promised them. This essentially came out of the 1950s, I believe, when employers were finding ways against prevailing wage requirements. So they'd say, fine, I'll pay you this, I don't know, $20 an hour, but you have to pay me back $5. So just write out the check to, you know, ABC Construction. So the government didn't like that, and they said, no, we're not doing that. We're going to make a law about it. So there are a lot of details within these provisions, and they lay out pretty much exactly what different scenarios might look like when it comes to incorporating wage determinations into a contract. And a wage determination is essentially, for those of you who might be unfamiliar, it is basically a floor under which you are not permitted to pay certain employees. And prevailing wage rates are what are used to come up with these wage determinations. So each job classification for pretty much each locality is going to have a specific wage that you have to pay, in this case, construction workers. And in this world, there are two types of wage determinations. There's one that's the general wage determination that, as I mentioned, covers localities. And then for the few situations where there might not be a general wage determination, you also have project-based wage determinations. These are essentially the same thing, only they don't last as long as general wage determinations. They're generally only about 180 days. And as I mentioned, they're less likely. They're really just in the small circumstance where you might find that another general wage determination doesn't already exist. And it can get complicated, but the reassuring thing to know is that the contracting officer ultimately is responsible for putting this into the contract. So the contracting officer is supposed to find out which wage determination applies and make sure that it puts this into your solicitation even before people bid on it. We just got a question. How do you handle an employee who is full-time salaried and they work on a contract over 40 hours in a work week. So if they're full-time and salaried and they are exempt from general FLSA requirements, then generally they're going to be exempt from, and this is more so in the service side of things. I don't think you're going to have a lot of construction workers who are exempt because it requires that you not necessarily be exercising manual labor. But if it's exempt from the FLSA requirements, these FAR Part 22 requirements don't generally apply. We do have a slide later on that talks about professional employees.
Yeah, there's also something that's not directly addressed in our slides called uncompensated overtime. So if you have a salaried person and they work over 40 hours in a work week, the whole point of the salary is that you don't have to pay them any overtime. There are a large number of contractors that pay these folks straight time over 40, and that is more common in government contracts than in commercial industry. And the reason for that is because there's this concept called uncompensated overtime. And for contracts like time and materials or cost reimbursable contracts, there's this concept that if you don't pay people the straight time hourly rate over 40, you might have to dilute your rate to the government. So in order to avoid diluting your rate to the government, because the government doesn't want you to get a windfall, so to speak, right? So there is this concept called uncompensated overtime, which is why some contractors still pay people straight time over 40. But it's not a legal requirement. It just might, depending on the type of contract you have, impact the rate that you can charge the government. That's not generally the case for firm fixed price contracts. So you might need to have an uncompensated overtime policy. You'll see that from time to time in solicitations where you need to have the policy. And if you need to see what that looks like, just give us a shout and we can help you with that. But that's really what you need to know is that salaried exempt people, you do not need to pay legally them overtime, but there might be reasons for you to pay straight time over 40, and that's completely permissible. I will say that you should look at your offer letters and make sure that they still appear to be salaried, because if your offer letters and the way that you're treating them starts looking like they're hourly employees and you received a DOL audit, the DOL might say, no, these people are not salaried, they're hourly, and you owe them the time and a half, not the straight time. So they need to walk, act, talk like a duck, like an exempt employee, other than the fact that they get this straight time over 40. So the language in the offer letter really matters. So just those are some things to watch out for. We also got a question about a collective bargaining agreement. Does this override the wage determination? If you've entered into a collective bargaining agreement with a union, yes, your your CBA is going to override a WD. And on some DBA projects, Davis-Bacon Act projects, you might have multiple things you're paying attention to. If they're doing this the way they should be doing it, your Davis-Bacon wage determination should basically match the CBA under Davis-Bacon. We'll talk in a minute about how that's different under service contracts. Under service contracts, if that CBA, the collective bargaining agreement, is done correctly and incorporated correctly, that CBA is your wage determination. So it's a little bit different from DBA to SCA, but you should understand that if you've signed, there are two things going on with collective bargaining agreements with unions, right? It's your contract with the union and then your contract with the government. So if you have a contract with the union that's signed and valid, you got to abide by it. So you got to know that.
One thing to remember through all of this is that unions were sort of an integral part of putting together the Davis-Bacon Act and the Service Contract Act. And so generally, whenever you see that you do have a collective bargaining agreement or you have a collective bargaining unit, there's going to be provisions within the FAR or within the relevant statutes that accommodate for union collective bargaining agreements, because that's basically the whole idea behind a lot of these statutes. It's also important to remember that the CO is ultimately responsible for putting this information into the wage determination and into the contract. And so to the extent that they get this wrong, DOL can go straight to the contracting officer and say, fix this, at which point the contracting officer, depending on whether it's Davis-Bacon or service contract, has the option to either incorporate a wage determination retroactively or just moving forward determined to put one in. And there's a lot of, you'd be surprised how many mistakes can happen along the way. There can be clerical errors. There can be perhaps they put in the wrong determination, perhaps they put in a reference to a wage determination, but didn't actually include that wage determination in the contract. And FAR Part 22 is really good about going through and giving you the exact process that happens when those mistakes are made. The other thing about Davis-Bacon is that employers, contractors are required to submit weekly certified payroll. And this includes not only submitting the payroll, but basically signing a summary page that signs off on what hours employees worked and what they were paid for those hours. This is a important process that applies to not just contractors, but subcontractors as well. So it's important that subcontractors, even if they don't have the agreement directly with the government, are aware of this requirement, and it's included in the subcontractor agreements. And a lot of clients can get in trouble if they don't submit these certified payrolls. It's a really big deal. And this is all part of the Copeland Act, essentially making sure that employees are paid the full rate that's promised to them.
And that it's correct.
Oh, yeah.
So you've got to be very careful and make sure that what you're putting in those certified payrolls is correct. Now, on these construction jobs, a lot of times you have subcontractors, you might have independent contractors, you might have people that are solo, essentially. They own their own company. You might have a carpenter that's kind of a lone wolf. He does his own thing. And there are very specific rules about how those certified payrolls need to be completed for each of those types of subcontractors, independent contractors, owners. So make sure that you understand before they perform the work what you need to do to get that certified payroll done correctly. Because if you have an independent contractor and you're supposed to get information from that person to submit the certified payroll, but you don't do that before their work's completed, they're off and gone. You know, it might be hard after the fact to get that information from them. So make sure that you're looking at that and those are done correctly, because if you don't, that can result in some liability under the False Claims Act, because you're making a certification to the government that you're going to do something correctly. I'm going to back up and answer a question really quick. It's a question about what happens when these wage determinations change, you know, midway through a base year or midway through, you know, an option year. That most often happens with the Service Contract Act. Sometimes the DBA, WDs update, but we see it most often with the Service Contract Act. In that particular case, the CO still has the obligation at the option year, not mid-year, but at the option year to update it and to provide the most current WD. They may not always do that. We see old WDs in contracts all the time where things are not, the new WDs aren't updated at the option year. But ultimately, it's the CO's obligation to do that. You can't make them do it. I would discourage you from increasing rates on your own prior to the modification, because the SCA and DBA are creatures of contract. So it's what's in your contract that controls. And you jeopardize your ability to get price adjustments. And Sarah's going to talk about the price adjustment clauses or reference them in a second here, but essentially you're supposed to get price adjustments. And so for these changes in the WDs, and if you increase them because the DOL put out a new wage determination, but the CO didn't incorporate it yet, you could be jeopardizing your ability to get that price adjustment.
Exactly. And the procedures for price adjustment are addressed in FAR Part 22. So it's sort of outside the scope of this webinar, but it's still important to remember that the FAR provides for very specific instructions on how essentially contractors can be compensated for when the contract increases due to an increase in the wage determination. And there are very specific, under both the Davis-Bacon Act and the Service Contract Act, procedures for how you go about requesting a price adjustment. And it's important that in order to receive this price adjustment, you don't provide employees with that additional bump to a new wage determination before it's incorporated into the contract, because ultimately what happens is it undermines your ability to get a price adjustment. So it's just important to remember that even though wage determinations can go up, ultimately the cost of that is supposed to be put on the government because it's their contract and their requirements that the price goes up.
Now, generally, you're not going to get G&A overhead and profit on that adjustment. So there are certain types of changes where you might be entitled. For example, if the DBA was never in your contract before and all of a sudden DOL comes in and says, oh, screwed up, now it should be in there, then you might be able to get the G&A and overhead and profit because you didn't bid with that presumption, right? But where everything has gone the way it should, you basically get the difference between what you were paying before and what you have to pay now, plus any associated taxes, but you don't get G&A, overhead, and profit. There are several price adjustment clauses that are different for DBA and SCA, so it's important you look at what's in that contract and to figure out what applies there. I do have a question about WDs. If there's a delay in incorporating it into the contract when it increases, would you not be able to get the contract adjustment to cover the increased cost from the date of the WD? Not generally. So let's say, for example, that the WD increased. DOL issued a new WD on June 1st, and your option year isn't until December 1st. The contracting officer would put that WD, or they're supposed to put that new WD in December, and it's a go-forward rate. And so they don't have to back it up to June 1st. They don't have to retro pay it to June 1st. That's not how it works. DOL can put, again, go back to this is a creature of contract. And so not only is the law concerned about the prevailing rates for the employees, but they are concerned about how the government deals with the price impact of that. And those contract changes happen at option years. So in fairness to the government budgeting process, they say that the WD has to come out more than 30 days before that option year. And then that's the WD that's supposed to go in at very least every 2 years. And then, it's that date going forward. Now, if they don't put it in at the option year and DOL comes in 2 years down the road and says, hey, it should have been put in 2 years ago, DOL could retroactively apply it, but not past the appropriate option year. So that's kind of how that works. So some of this we've covered in Davis-Bacon. Service Contract Act is going to apply to service work. And the question I always get in these trainings is, for things like Sarah mentioned, like painting and repair, there are service positions that cover those as well. Okay? So when do I know if it's SCA or DBA? Sometimes there's work that's both SCA and DBA. It's both service work and construction work. And sometimes you'll get a solicitation that has both Davis-Bacon WDs in and SCA WDs in. And you really have to look at the nature of the work that's being performed. Is it work that's primarily, somebody going and doing basic repair on things, like a maintenance worker type position? If it's a general maintenance worker type of position where I'm painting a room and then I'm fixing a lock, that's probably service work. If it's something where we're building a new building for the government and there is some general labor work that needs to be done in building that building, that's Davis-Bacon work. And sometimes it's not very clear. And so we really have to dig in and figure that out.
And we talked about how it's the contracting officer's responsibility to put the wage determination into the contract, but it's the contractor's responsibility to determine the classification of work that's being performed by employees. So even though it's a confusing question, we got a question about this that's saying whose responsibility is it, and ultimately it is the contractor's responsibility because you're the ones who are most familiar with the sort of work that ultimately needs to be performed to get the contract done.
Exactly. Now, the question really related to sometimes the government is telling you what labor cats they want assigned. I would carefully scrutinize the language that's used in those solicitations that says, oh, it should be a general clerk 1, or it should be a laborer, or or whatever they say it should be, because the DOL could care a hoot about what the government put in that solicitation as far as what they think that it should be. The question is whether the government made it a contract requirement for you to classify somebody a general clerk 1 or a general clerk 3. Because if then DOL came in and said, no, it's supposed to be a secretary, not a general clerk. The secretarial positions are much highly paid service positions. They're going to make you back pay for secretary. And then the question that we're usually dealing with is, do we have a basis to then go ask for that adjustment from the government and say, government, you did this wrong, and we relied on that assertion in the solicitation when we bid, and so now we need this price adjustment. The same goes for if you get a solicitation and you classify workers and then you show up on the work site and the work is different and you have to reclassify somebody. You would have an obligation to say, no, government, this is not what you asked us to do. You're asking us for more. We need an adjustment. We need you to modify the contract in order to make sure this is right. So again, when the government classifies, make sure that it's clear that they're making it a legal obligation, that they mean the same thing by general clerk 1 as the SCA means by general clerk 1. Okay, because they're two different questions. It's what's required by your contract and what's required by labor law, and that affects your bid. So it's good. I like to use the Q&As to try to flush some of those questions out. Sometimes you can also use pre-award protests if you think that there's not a WD or it's not correct or there's something wrong, because obviously if everybody's bidding on this language, you want to make sure that you're not at a competitive disadvantage just because you understand that ultimately DOL is going to put the impetus on you to classify these employees correctly under the wage determinations. So that's going to be really important. Just quickly, the Service Contract Act only applies in the United States or U.S. territories, and it's for service work. So it's, nurses, secretaries, lawn maintenance workers. It has some transportation workers, bus drivers. I'm probably missing a whole janitorial. We have a lot of janitorial contracts.
Unlike the Davis-Bacon Act, the SCA has a whole list of positions that qualify under it. That's published by the DOL, and you can essentially look up and see the full scope of work that's performed under the scope of the Service Contract Act.
And the whole point, Davis-Bacon, one unique thing about Davis-Bacon is that you can take the wages and fringe benefits and mishmash them together, and it really doesn't matter whether you pay all the money in wages or more money in benefits. You aggregate them to get the total prevailing wage. For the Service Contract Act, they're very distinct categories. And so most current wage determinations put the H&W at 427 or 441-ish, unless you have sick leave in your contract, and then it's 413, which we'll talk about briefly a bit later. And then you have a wage rate, and you've got to keep them separate and distinct. You can't mishmash them together and mix them around. You got to keep them separate and distinct. So what's in a wage determination under the SCA that might be a little bit different than the Davis-Bacon Act? Again, there are two types of wage determinations. Some's odd numbered, some are even numbered. You also have non-standard wage determinations where you get these funky, weird positions, and they might have standalone wage determinations. The odd and the even numbered wage determinations tell you how you pay the fringe benefits. And so whether you have to pay the H&W up to 40 hours a week or for all hours worked, or whether you can aggregate all of the benefits for all the employees, or whether you have to pay them on an individual basis. Most of the wage determinations you'll see are individual-based odd wage determinations. They're odd numbered, and they say you have to pay that H&W rate or equivalent bona fide fringe benefits per person. So you have to account for each individual, and everybody should get at least that minimum amount of fringe benefits, as opposed to averaging it among your full workforce. And you only have to pay that up to 40 hours a week. You still have to make sure that you pay the FLSA and state minimum wage. So if your state minimum wage, if you're in New Jersey or California or Washington State, and that minimum wage is $15 an hour, you're generally going to have to meet that state minimum wage, which is higher. The FLSA minimum wage is $7.25 an hour, So it's pretty low. It's underneath the federal contractor minimum wage, which is $10.35. So for the most part, you're going to be paying at least $10.35 on these contracts. That, just as a aside, that federal contractor minimum wage, which I think we'll touch on later briefly, you need to make sure that that's going to go up every year. So you got to check it every now and then.
And just as a reminder, these are for exempt employees who are service workers. Non-exempt.
Yeah, sorry about that. So this would not apply to your exempt salaried folks. So all of these things would not apply to exempt salaried folks. It's very important that you really think about who can be exempt and non-exempt, because the most common investigations we get are, should we really have classified all of these people as as exempt? And then it turns out that the DOL disagrees, and we get into an argument over whether we classified correctly. So it's really critical that you're involving HR folks or whoever you have at the outset of bidding on these things, so we know what types of wages and fringe benefits we can incorporate. We always get questions about vacation under the SCA. The right, to the letter way to do vacation is to do a vesting system, which means during the first year of employment, you get no vacation at all. And when you hit your anniversary date on the contract, so not just with you, the employer, but on the contract as a whole, it could be with a predecessor contractor, you would get your full allotment of vacation for the year. And then you can use it that next year. And then on the next anniversary date, whatever you have not used gets paid out to you. And then you get your next bucket. There are ways to work out an accrual system, but recently we've seen more pushback on it. So you need to think about whether, what kind of risk you want to take if you're not using a vesting system for vacation. Holidays are outlined in the wage determination, so you do not have to use the exact holidays in the wage determination if you don't want to, but employees have to be put on notice of the equivalent number of holidays that you're giving them. So maybe you're working on a site that's open on Good Friday, and Good Friday is a holiday. So you might want to give the employees their birthday off or whatever it is. That's fine, but they have to be put on notice well in advance of what holiday you're going to give them. There are also a lot of miscellaneous things. It's probably a good idea if you have one to just read through the darn thing every now and then just to see what's in there. If you have a hazardous type position, you might have to pay some hazard pay. It might cover uniforms. Sometimes you'll get wage determinations that just look weird, and they have some history there somehow, but they just show up in these contracts. And so while a lot of them look similar, it's really important that you understand what your obligations are there. Again, if there's an increase in your wage determination, you can get a price adjustment for it if you have an actual difference in your wages and fringe benefits. We have a couple more questions. One deals with if there's a delay of incorporating the WD into the contract.
there's one specifically about subcontractors and whether they are required to, it looks like, pay the same rates and get a WD from the contract. So ultimately, if you're a subcontractor, the wage determination should be incorporated through your contract that you have with the prime contractor.
Yeah, there's a requirement that all WDs are flowed down to subcontractors. So if you're a prime, you need to make sure that you have flowed down the wage determination to a subcontractor. If the primes told you that the contract is not SCA and they don't flow it down, you don't have any contractual obligation to comply. Ultimately, the prime contractor is the one that's going to be on the hook. I would make sure that nothing in that subcontract has an iota about the SCA, though, and that the WD is not hidden in there somewhere. This happens even if you're the prime sometimes, where you have a bunch of non-exempt employees, but they didn't put the SCA in there. Still not your problem. These are creatures of contract. So I would not recommend that you preemptively make them, SCA folks. That generally increases your price. But I suppose if you wanted to, you could price it that way. Maybe you'd still be okay. And if there were a DOL investigation down the line, you wouldn't have to worry so much about it. But generally speaking, if it's not in there, you don't have to comply with it. You go on just like it were a commercial, type wages. And then if the DOL comes in or it's incorporated later, you can always get the price adjustment once it's incorporated. We have another question. If we were told the employee was classified as a non-exempt employee, they were subject to the H&W rate, is this true? Generally speaking, if you have non-exempt employees and it's on an SCA contract, so the SCA FAR clauses are in there and you have a wage determination in there, if the employee is non-exempt, meaning they're hourly paid, yes, they're service workers and they have to be paid the requisite labor rate and H&W rate. Now, if there's no SCA in the contract, it doesn't matter. It doesn't apply. But if the SCA is in there and they're non-exempt, they need to be classified and paid appropriately.
So we talked a little bit before about professional employees. These are employees who are not subject to FLSA overtime rules and who are generally accountants, lawyers, doctors, engineers. There's a sort of a section that says we haven't forgotten about these professional employees. You have to pay them fairly and properly, which is pretty much as detailed as the regs get on paying these types of employees. And that's because FAR Part 22 really does focus on these service and construction workers, and ultimately employees who are exempt are not really the interest of what they're getting at.
The only weird exception to that, I think, is the new sick leave executive order, because the new sick leave executive order, and that's FAR 52222-62, that one, if it's an SCA or a DBA contract, the sick leave requirements apply to professional employees as well as non-professional employees and those working in connection with a covered contract. Now, you can finagle it a little bit better with the professional employees. You can usually use your paid time off policy, but that's one of the only ones that's really applicable to professionals.
And then regarding service workers, there's another fun EO that was recently introduced. I think it was 2013. The non-displacement of qualified workers, which essentially says that if you're bidding and receive an award of a service contract, then you are obligated to extend offers or give the current employees who perform work on that contract the right of first refusal. This means that you have to make them essentially a bona fide offer of employment. And what does bona fide mean? Ultimately, you're looking to hire them. There are some requirements that if for some reason you hire them and let them go within 90 days of the start of performance, then that's not actually a bona fide offer. You didn't mean to keep them employed unless you can show that there were some actual performance issues. Now, there are some exceptions to whether you need to offer employees the right of first refusal. It doesn't necessarily need to be extended if you don't need all of the employees who are currently performing on the contract. Suppose you think that you can do it with 15 employees instead of 20. You're allowed to just hire as many employees as you think necessary to complete the work. Another exemption is where you have essentially a written statement from the government saying that they have what it's called is written credible evidence of poor performance or unsuitable performance. And it's really not clear what that means, whether it's a one-time note that a contracting officer maybe noted about one employee. The rules and regs have sort of explained that it doesn't mean it has to have been for a terminable offense, but something that makes you question whether these employees are able to perform the work in a suitable way. And how do you know how do you have this information? Technically, the incumbent contractor is supposed to provide a list of all the service employees on the contract 30 days before they are done with their completion of performance. This doesn't always happen. And unfortunately, if you don't get that list, you still have this obligation to make these offers. But this list is supposed to help you know who those employees are. It's also...
the CO is supposed to help you get it. Again, that's challenging, but it's supposed to go through the CO. But what often happens is you show up on site and you're scrambling during a transition period or the day of. People just kind of show up but you got to give them that. Technically, you don't have to give them their offer in writing, but you should.
Just to show proof, because you have to give them at least 10 days to consider it. And so when you put that in writing, it makes it clear, listen, we told them on the 1st, it's the 11th, they haven't accepted, so we're moving forward with another hire.
Yeah, and in that letter, you want to make sure that you say that the offer expires on such and such a date so that they don't come back 2 weeks later and say, but I'm here, I don't have a job. Some other fun things that we see are, you don't have 10 days. So I get that call all the time. Nichole, the contract was awarded yesterday. I start performance tomorrow. I don't have 10 days. Realistically speaking, I've rarely had a situation where employees were like, I think I'll just take this 10 days off. Most of the time they're gonna onboard quickly, but we got to put that 10 days in the letter.
And remember, these are service contract employees. And so whatever wage rate is in that wage determination, that's what they should be paid. If the government went ahead and with this new, more recent contract updated the wage determination, then whatever that number in that wage determination is, that's what you're supposed to pay them.
Yeah. Now, they don't have to be given exactly the same payment as they received under the prior contract, right? So you don't have to say they were given a higher wage rate than the SCA WD. You don't have to give them what they were making with the prior contract, as long as you're paying the SCA rates. As long as you're meeting your legal obligations under the SCA, you're fine. You don't have to give them the same benefit plan, right? I mean, you have to give them at least the level of benefits that's required by the SCA, but you don't have to give them the gold standard plan. And again, generally this only applies to service contracts. So the first question is, does the Service Contract Act apply? And the second question is then the non-displacement rules should be in that solicitation if the SCA is also in that solicitation. Did you talk about the ongoing obligation for 90 days? Did we talk about that?
The performance and what it has to be a good faith offer. The last thing that's just sort of, standard, you have to provide notice to employees that they're entitled to this benefit. So just post somewhere on the work site.
Yeah, and sometimes what we do for contractors who've lost a contract but are trying to ease the notice to employees is sometimes we tell them, you should be getting this offer, or you will qualify for a right of first refusal. Now, if the next contractor doesn't have as many positions available, then you don't have to offer those positions you don't have, right? You only have to offer the positions you have. But it's sometimes a good way to kind of ease the transition with the workforce.
Mm-hmm. And if it's not an SCA contract, then there's no obligation to give workers that 10-day requirement. You can give them whatever turnaround you would like your offer to include.
Exactly. So if it's not SCA, you can do what you need to do to get people onboarded quickly. So let's talk a little bit about, and we've gotten a lot of questions, and I really appreciate it. We're going to try to get through our content and get to the questions because I know that's what you guys are interested in. Very quickly, the non-discrimination policies, I think, are one of the most commonly overlooked parts of FAR Part 22 because we assume that it's basically the same as the other federal requirements, but it's a little bit different and a little bit more onerous. So the types of protected classes are race, color, religion, sex, national origin, sexual orientation and gender identity, which is relatively new, age, veteran status, and disability. And the OFCCP, the Office of Federal Contract Compliance Programs, is the body that governs this. So if you have an employee who feels they've been discriminated against, or you failed to hire them because of their disability, or you didn't give them a reasonable accommodation, they could, if they wanted to, instead of going to the EEOC, they could go to the OFCCP to have their grievance adjudicated. And the OFCCP, unlike the EEOC or even the DOL, can show up randomly. They have a list, and they can just go through it and show up with a notice that they're going to audit your contract. It's also a little bit different because you're supposed to take affirmative action to hire these folks. So you're actually supposed to go out and look for these folks. And so you're supposed to make sure that your advertisements for employment are going out with, certain language, that they're being distributed. They might have certain language that says that you don't discriminate on the basis of veteran status or one of these protected classes. In every subcontract that you have that meets these thresholds, there is a certain EEO clause that needs to go full text into that subcontract. And I would bet most subcontracts that come through my office don't have it. They might have some reference to the FAR clause, but you're supposed to have the full clause in there. You're supposed to keep records, even if you don't have to have an affirmative action plan, which generally only applies when you're over 50 employees and you meet certain dollar thresholds on the contract. Then you're supposed to have an affirmative action plan, which says, I've done this analysis of all of my employees, and this is where I think I have room for improvement. You're supposed to do that. You're also supposed to file an EEO-1 report with at the EEOC that says, basically, these are all my folks, and these are all the ages, races, genders, pay. A lot of different information goes into that EEO-1, which you're supposed to do at 50 employees if you meet these certain thresholds, right? But if you don't have 50 employees, you don't get out of complying with this stuff wholesale, okay? You still have to make sure that you keep records of your advertisements. When did you advertise for certain positions? You have, different types of obligations still to make sure that you're taking affirmative action to employ these individuals. For veteran status and disability, those are actually covered by a different regulations than the other protected classes, and they set benchmarks for compliance. So they want you to hit, it's usually between 6.5% to 8% for veterans and disabilities. You might, at a certain point, at a certain threshold, have to have applicants and employees fill out self-identification forms so you can track this information as well. There is nothing really that's going to happen that's horrible if you're not meeting these benchmarks. And you can go out on the website and find out what these benchmarks are. There are a couple of different ways to figure out what the benchmarks are. But the key thing I want you to understand is that if you're not meeting them, that's something that should be going in your affirmative action plan or something that you should be paying attention to. And then if there's some systematic finding that you're not doing what you need to be doing to actually find veterans or find those with disabilities, then the OFCCP could say, hey, this is what we want you to do. But generally speaking, it's not a quota per se. It's a goal that they want you to achieve. Miscellaneous employee rights.
So this is just sort of the hodgepodge section where they've found some additional things that they think contractors should be thinking about. We mentioned the National Labor Relations Act earlier. Employees have a right to engage in protected activity, including the right to talk about terms and conditions of employment and other concerted actions such as organizing or just generally working towards unionization. We also mentioned that employees on federal contracts are required to be paid a minimum wage, which is different from the FLSA minimum wage. Currently, this amount is $10.35. However, it changes each year, generally going up by about 10 or 15 cents. And then we also mentioned, and this is much more complicated than what the one line indicates, but recently, there is an EO sick leave policy that was incorporated into a lot of contracts out there. And this requires that employees working on contracts covered by the sick leave policy provide at least an hour of sick leave for every 30 hours worked. And there are a lot of requirements that go into this. For example, you must allow employees to accrue up to 56 hours of paid sick leave throughout each year. They have to be able to carry over sick leave. You can't put a cap above that amount. There's a bunch of small little details that go into this that make it much more complicated, including varying fringe H&W rates that apply depending on whether or not you include that sick leave. But just be aware that it's out there, and
if you see it in your contract, it should start popping up in new solicitations. We're seeing it more and more. And so it's a good time to take a look at the sick leave policy that you have and figure out, am I going to treat the exempt folks that this applies to? Am I going to use their general PTO policy? Mm-hmm. You can amend your PTO policy so that you're compliant with the sick leave stuff for exempts. For non-exempts that are SCA, that you can't do it. You've got to provide a different sick leave pool than vacation pool, mm-hmm. just because the way the regulations read.
Because basically you have to pay out vacation, but you don't have to pay out sick leave. So I guess if you wanted to pay out sick leave, you could.
Yeah, but then you have rollover requirements, which is the other problem. So with sick leave, you have to allow the rollover from year to year, where vacation for SCA folks, you have to pay out year over year. So it gets much, much more difficult to have a combined PTO policy for those non-exempt employees. So it's a good time to just look at those things. For prohibited labor policies, basically don't involuntarily make children labor, and don't traffic humans. The trafficking of the humans, we joke a little bit, but it isn't a big issue for especially internationally. If you're contracting internationally, it includes, you've got to have a plan in place, a compliance plan if you have a contract greater than $500,000. But even if you have a lower value contract, the definition is so broad, it applies to employees going off to Vegas to get into a little trouble. So you do have to let your employees know that this is an issue and that they can't engage in this behavior. The biggest one that we see is actually the labor stuff. So we see a lot more labor than, say, prostitution. And it's a pretty broad statute. So it's a good thing to keep in mind and to pay a little bit of attention to.
And just some contracts require that contractors put their employees through E-Verify programs. So you should definitely check and see whether the correct FAR provision is in there.
And most contractors should be using E-Verify to verify employment at this point in time. Drug-Free Workplace Act, this is kind of our last big area. And the reason we included this, even though it's in FAR Part 23, and we're really not getting into the other stuff in FAR Part 23, but we see this problem more and more and more, which is basically, if you're working on a contract, your employees can't sell, distribute, use illegal substances. The problem that we're seeing now is you have all these states that are legalizing marijuana. It's getting increasingly, with the tight labor market, harder to hire people that can clear a drug test because people are engaging in recreational use of marijuana on the weekends or at night. They might not be high at work. And the question I always get is, what do I do? Well, there are lots of options here. We should talk about what's going to work for your workforce and what contracts you have. If you have a safety sensitive workforce, you might have a lot less flexibility here than if you don't. And, technically this doesn't even require pre-employment screening, although some contracts require it. So there are ways that we can look at your policy to make sure it's compliant. The other issue we have is the intersection with the Americans with Disabilities Act, in light of the fact that there's so much medical marijuana permissible out there right now. So how do you do that when the testing for medical marijuana hasn't really caught up to the times? And do we have accommodations that we can provide for individuals that have disabilities that use marijuana to control pain? And again, they can't be high at work. But the question is whether there is some flexibility off of working hours. And for some employers, we can build that flexibility in. For other employers, it doesn't work. Again, it's a good time to check your policy and see how you're administering it. So what do we have for best practices? Just to wrap up, read your solicitation carefully. It's all about what's in there. It's all about what's in your contract. Don't ignore a FAR provision because you don't really know what it means, because half the time I have to do a double take. So there's a lot of stuff in there, right? And you're like, yeah, that's the 18,000 FAR provisions. But make sure you know what FAR provisions are in each contract and whether you have to comply with something that's in there. Make sure you're flowing down. If you're a prime, make sure you flow down necessary provisions to all of your subcontractors. And if you're a sub, to your first or second tier subs. And when in doubt, give somebody a call. Most of this stuff we're dealing with day in and day out. We're getting these same questions over and over and over again. You are not alone, and it doesn't take a good practitioner that long to answer the question. So it's better to be safe than sorry. I apologize if I didn't get to your questions today. Sarah and I will get back to you as quickly as possible on all of these questions. A lot of really great questions I wish we could have answered today, but we're already over time. So we thank you so much. We appreciate and understand that you could do something else with your hour. So have a great afternoon.